Now, the extradition hearing of self-proclaimed prophet Shepherd Bushiri and his wife has been adjourned for a week. This is to give the defence time to file for a recusal of the magistrate. The Bushiris, of course, fled to Malawi last year after being granted bail here in South Africa. They're being charged here with theft and money laundering, and the government has applied, of course, for their extradition. That happened in December. Let's get an understanding of what needs to happen as this case unfolds. I'm joined now by Advocate Mphilonhle Baloyi. Good evening, sir, and thank you so much for your time. It was interesting what happened in court this afternoon because they want the recusal of Magistrate Patrick Chirwe. They're saying this is a case of evidence bias because he's the same magistrate who issued a warrant of arrest against the Bushiris. Is there precedent for that sort of thing? It seems like a fairly standard thing to do, to issue a warrant of arrest. How does that show bias in any way?
Good evening, Sally, and good evening to the viewers. We need to understand firstly that the current law that we're dealing with falls within the context of public international law. And this particular matter pertaining to the extradition is governed by international laws and conventions and certain protocols. Now, at present, there is a current matter of recusal in the Malawi Magistrates Court in Lilongwe for the recusal of that magistrate because they accuse this of the belief that there is bias simply because the previous warrant of arrest was issued by him. Now, on issues of recusal, there are many things that need to be considered. And on this particular one, it will be for the court to decide as to whether there is that inherent bias and that suspect of actual impartiality.
All right. So we have an extradition treaty with Malawi, but we've seen quite a number of false starts in this matter. There was talk about who's supposed to apply, and it went to the wrong official, and there were lots of delays. How tricky is this process, even when there is a treaty in place?
The process is indeed tricky because, remember, this is a well-governed process. Firstly, it is governed within our own country, within our own laws. We do have the Extradition Act 67 of 1962. We do have the SADC Extradition Protocol. And over and above that, we do have the different treaties between the involved countries. So what then happens is that the countries have to agree reciprocally that they will extradite any person accused of a commission or that has been sentenced or is still running trial, to bring them back to that particular country to run trial, to face trial, and to basically face the charges that have been laid against them.
So,
now, how this now plays out in South Africa is that South Africa then has to request the accused from that different country. It's a diplomatic channel that has to be followed in consultation with the minister, and then the extraditing country either gives this person back or not.
Yeah, so there's different levels of interaction that are required, as you're explaining. So here's the thing, though. The Bushiris are claiming that they fear for their lives here in South Africa. What are the chances, really, of them ever coming back to South Africa to stand trial? Because surely no home country is going to send back one of their citizens when their citizens claim there have been attempts on their life and they fear for their lives.
Well, insofar as that is concerned, it becomes slightly tricky because that can strain international relations between the two countries. But insofar as extradition laws are concerned, a person will not be extradited if that person will not face a fair trial. So the main emphasis here is, will the Bushiris have a fair trial? And if that is the case, then they should be brought back. But if there's evidence showing indeed that they will be prejudiced in any way, then the extraditing country may not extradite them. The common reasons around that is for the reasons of race, gender, religion, etc., or political opinion. And in this case, none of those have actually been cited, except the fact that they fear that they will not have a fair trial, and attempts have been made on their lives, and they fear for their own safety within South Africa.
All right, so we've got to hear a decision on the recusal, the request for recusal of the magistrate. How quickly do you think it'll get underway after that?
Well, it might not get underway as quickly as we anticipate or as we might desire, because on Monday it's the recusal of the magistrate, and then on Tuesday they go to the High Court to actually contest the validity of the warrant of arrest. So the extradition matter itself is not going to be heard within the next couple of days, at least, because there are still these smaller applications which need to be heard before the main extradition hearing.
Gosh, so there's quite a way still to go. Thank you so much for explaining that also clearly to us. That was attorney Mphilonhle Baloyi.